Good morning and welcome again to you and to our panelists. Recently, I was fortunate to have spent a bit of time with NRCS Chief David White. With him, we seem to now have leadership in Washington to assist us as producers who have been faced with severe drainage issues these past few years. Chief White has acknowledged that tiling is happening without NRCS involvement, but he supports tiling if it's part of a water management plan. He has directed his offices to provide technical assistance so that we can have a healthy environment and be productive at the same time. He has asked his staff to be consistent in their performance, is providing additional resources to address timeliness in making determination, is promoting friendly attitudes and customer service within his agency, and is making the appeal process less controversial. Today, we are privileged to have three experts in the field of drainage with us. They will each address their area of expertise, and then we will open the floor for your questions. Michelle Burke, seated in the middle, is the area engineer for the NRCS and is based in Brookings. She was raised on a farm near Centerville. Her work experience includes projects such as dams, pipelines, irrigation, gully control structures, waterways, animal waste management systems, and wetland hydrology assessments. Next to me is Dr. Chris Hay. He is an assistant professor and extension water management specialist in the Department of Agricultural and Biosystems Engineering at SDSU, where he teaches and conducts research in the area of soil and water engineering and agricultural hydrology. He has several years of experience in consulting with government and industry in the areas of water resources engineering and environmental management. And to my far right, we have Gary Lestico. Gary is a native of Elk River, Minnesota. He received his law degree from William Mitchell College of Law. Since 1994, he has practiced with Rink Noonan's team of attorneys in St. Cloud, where he concentrates his practice in environmental and criminal law. The Rink Noonan firm will be presenting a drainage and wetland conference in St. Cloud in February. And following today on the Wheat Growers website, we will have a link for contact information for each of these three individuals. We thank them for being with us. And I would like to ask Chris Hay to give introductory remarks, and thank you.
All right, and good morning, and thanks for having me here. As he mentioned, I come out of the Ag and Biosystems Engineering Department at SDSU with an ag hydrology focus. A large part of what I do is related to extension and public education. The big ag hydrology issue over the last several years has been drainage, so that's been a large part of my focus. We're also involved in getting started with some research projects looking at what the hydrologic impacts of additional drainage in South Dakota will be, and is looking at a few practices to try and keep some of the benefits of drainage, but also address some of the impacts. And so, just kind of introductory. A lot of, certainly not news to you, but with this long-term trend we've had of increasing precipitation, and especially dramatically so over the last couple of years, combined now with high commodity prices, high land prices, and changes in technology that have made it easier for folks to install drain tile. We're seeing this huge increase in interest in drainage in eastern South Dakota. And we know the good things that have come with that from an ag production standpoint. The two big ones, we're going to make field operations more timely. We'll speed those up. We'll remove excess water, get that water table lowered, and reduce excess water impacts on crops. And so with that, we're going to get some increased yield out of that. That's what we're after. We'll have some other impacts, reducing soil compaction, helping handle salts and get salts flushed out of the root zone, potentially helping implement some other conservation practices. So certainly a number of benefits that come with ag drainage, certainly been bared out over a number of studies. Not too much disagreement over that. But there's also some impacts that come along with the practice, and that's where a lot of the controversy comes in. When we talk about impacts, it's important to make the distinction of whether we're talking surface or subsurface drainage, because the two act very differently. With surface drainage, we're using land shaping, ditching, trying to speed water off the landscape before it even has a chance to infiltrate. With subsurface drainage, now we're putting typically perforated plastic pipe, 3 to 4 feet down in the soil profile. And as a high water table builds up, we drain that water into these drain tiles and eventually out to some outlet. So because they act differently, they have different impacts. And when we talk hydrologic impacts, with surface drainage, again, we're speeding that water off the landscape, not even trying to allow it to infiltrate. And so that tends to, again, make water move more quickly, also tends to increase peak flows, and we're going to have more runoff because we're moving that water off quickly. With subsurface drainage now, we're lowering a high water table, which encourages some more infiltration. And so we tend to then lower peak flows coming off the field, spread that out over a longer time base. So in some cases that can have some beneficial impacts potentially on flooding, but certainly by concentrating that flow at a specific outlet, we can have some localized flooding effects. And so having access to a good outlet becomes very important when we're looking at that. When we talk water quality impacts, they really kind of relate to the hydrologic impacts. If we have more surface runoff and speed that off, we tend to help increase some of those pollutants we associate with surface runoff, mainly soil erosion or sediment and phosphorus. With subsurface drainage, we're now moving more water through the soil profile, and so we tend to reduce surface runoff, reduce soil erosion, reduce phosphorus losses. But then on the flip side, that water moving through the soil profile can pick up any soluble contaminants, and the one we tend to worry about is nitrate and nitrogen. So all other things being equal, we tend to be concerned about higher nitrate losses through subsurface drainage systems. So I guess one of the big areas then as far as where drainage is going, what we're looking at is drainage research to try and address some of those issues then is a suite of practices we call conservation drainage. These are still emerging practices, but practices that we're looking at as ways to keep those good things about drainage, but also try and address some of the impacts. And so that's probably a good little introduction, and maybe I'll pass it along.
Okay, thanks, Chris. My name is Michelle Burke. I'm with NRCS, based out of Brookings, South Dakota. We have an area office there as well as an area office in Pierre and Rapid City. We provide technical support to our county offices, which I'm sure many of you have probably worked with. The main focus of our agency is to provide technical assistance to landowners and operators who are interested in doing conservation practices. So we provide planning assistance. We'll work with you from that standpoint on the planning end, also from the design end, and we also offer some financial assistance. Anything to do from engineering, where I operate in, to agronomy, also range management practices. And of course, in addition to our responsibilities for technical assistance for conservation work, we also are charged with doing determinations for highly erodible land and wetland conservation. So what we're out there doing is making those determinations and providing that information to the owners and operators that need to make the land use decisions that could affect their eligibility for farm program benefits. So we are not regulatory. We are concerned with eligibility for farm program benefits. When it comes to tiling, we've, of course, seen a major uptick in that in the last few years with crop prices, with land prices. So for those folks that are participating in the farm program, you'll need to know where your wetlands are at if you're planning a tiling project, and you'll need to know whether that proposed project would impact the wetlands and possibly affect your benefits. So in order to do that, we'll go out and make a certified wetland determination on your ground. Any determination we've made after July 3rd, 1996 is considered certified. We typically do a bunch of off-site work as far as reviewing soil surveys in our office, reviewing Usgs topography maps, any prior determinations that have been done, and as well as a large amount of photography that we have available in our offices. And that information is available to you if you're interested in looking at it as well. We also go on site to look at indicators in the field, And we do need to document ditching and tiling that was done prior to 1985, prior to the Food Security Act bill. So when we complete that certified determination, we will provide you with a letter explaining it, a form that goes with it, as well as a map. And the map will be on a photo background. The sites will be outlined with the location, the size, the label that applies to that site, as well as mapping out the pre-85 drainage activity that's happened on that land. And for any tiling work that's been requested, we also provide what's called a lateral effect distance, which basically is what you may call a setback. So if you plan to do a tiling project near a wetland, we would determine how far away you would need to stay from that wetland so you would not jeopardize your benefits. So, and there's a lot of site-specific information that goes with that, so we encourage you to work with your local office on that. Also, as was alluded to earlier, we are starting to get involved in these emerging technologies, drainage water management, looking at a systems approach to try and manage the nutrients that are on the land and leaving the land. So things like drainage water management, bioreactors are a new technology. We'll be looking into those. You may be hearing more about that from us. So we'll be working cooperatively with Chris and other folks to get those things implemented. I believe that's it.
Thank you. My name is Gary Lestico, and I'm an attorney at the Rinke Noonan Law Firm in St. Cloud. Originally grew up on a farm near Elk River, Minnesota. It was a kind of combination dairy crop farm. I, after that, worked at the USDA, what was then the Agriculture Stabilization Conservation Service, today's FSA, or Farm Service Agency, for 6 years, working on commodity program verification, that type of thing. Went to law school, and I have been practicing at Rinke Noonan for 17 years. I'm admitted in the state and federal courts of South Dakota, North Dakota, and Minnesota. And the substantial part of what my practice is today, what I work in, is representing landowners, agricultural primarily, in regard to wetland and drainage issues. And so I have clients in all 3 states, South Dakota, North Dakota, and Minnesota, that I assist with either the original kind of going through the process to determine if they're going to do some drainage, how the law interacts on both state law, federal law, farm programs specifically, common law, and how the law allows and limits the ability to drain on to other properties from your own. And the law in South Dakota is different in some ways than North Dakota and Minnesota. They all have the same general policy behind them, but there are specifics with each of that law. And so when a landowner is looking at initiating a drainage project, there are just a wide number of areas to look at. There's the science part of it, and then there's the compliance part of it. There's keeping your neighbor from suing you or winning if they do sue you part of it. So I work with landowners to assist them with their drainage projects. If they get in trouble, assist them on that. Some of that is in conjunction with the NRCS office. Occasionally it ends up being an adversarial process. Most things can get worked out. And the concept of drainage and tile specifically in South Dakota is something that we've seen at our firm, and we have 28 attorneys. 4 of us do almost exclusively water-related law. Now I'm one of those, and then we have attorneys that work in associated issues with those that come in and assist us on certain kinds of issues. Minnesota's had tiling for decades, probably well over a century, in a very substantial way, and so it's a much more consistent part of the kind of the culture of what's being done there. In the Dakotas, we've seen that tiling has taken on a life of its own recently. It's wetter, commodity prices are higher, land prices are higher, and it's a way to maximize the value of that property and maximize the profits each year with the crops. So we see a lot more of that. there is a reluctance with some landowners to get involved with it because of the complexities of it. You're worried about complying with the programs they have to comply with. South Dakota law is fairly open as far as the state limitations under state law, but there are some limitations you have to stay within. And then the federal farm programs have limitations. Landowners are making decisions about whether to stay with the federal farm program or whether to step out of it to be able to do the tiling they want to do and maximize the profits they get from that property. And we assist those landowners in whatever way we can to kind of work through all those issues.
Thank you. We will have Bill and Steve with microphones out here and ask for your questions and comments. I will break the ice with one for Michelle. I know under federal statute the determination of a wetland theoretically can only happen by an NRCS employee, but I also hear stories from my neighbors that, oh, my cousin's uncle's brother is a soil science expert and he made the determination. Would you give us a little clarification on that, because the determination is the key to what we do afterwards?
Yep. That's right, and we do have a number of folks that have signed up for wetland determinations and are on the wait list. And in an effort to try and speed that up and get you what you need to make your decisions, we have our staff, which of course works at completing wetland determinations. We have roughly, I work in a 21 county area, and we have roughly 40 employees who have the necessary training and experience to do that. That's a portion of their jobs. And most recently, Chief White, the chief of our agency, has also supplied some funding where we could hire some additional staff on a temporary basis to assist us with that. So we have hired in South Dakota 7 additional staff and matched them with 3 staff that work full-time on wetlands. So we have a total of 10 that do that on a full-time basis. The funding for that particular project runs through the end of September of this year. At this point, we don't know whether that can be extended or not. In addition to that, as you mentioned, we do have 3 recently retired colleagues of mine who have extensive wetland experience who have gone out and begun consulting work. Now, they can go, if you're interested, you can certainly hire those folks to come out and collect the data for us. They would need to submit that back to us, and we are obligated to review that, make sure everything is in order, and then we could go ahead and issue that determination.
Part of our problem with all our wetlands is half of these things are silted in, because of the cattails and everything that's been growing in the last few years. What can we do? Because some of these didn't used to be wetlands because the water flowed through them. Now it sets in them. And as far as cleaning them out, getting back to some of the original heights that were recorded back in the 50s and 40s, elevations.
All right, good question. And of course, we see a lot of that. There's a lot of old surface ditches out there that were put in place the 40s, 50s, and 60s. And depending on where you're at, some folks keep cleaning those out. Other folks have let them go. And you can certainly do maintenance on anything that was there prior to 1985. And we will assist you as far as determining the depth of that ditch to give you a clean out depth relative to the bottom of the wetland. Same thing goes for tile. Any old clay or concrete tile out there that was installed prior to 85, if we can get that located and get the sizes on that, you can certainly replace that if that's silted shut. Does that answer your question? Or?
Not really.
Okay. Sorry. Okay, we'll try again.
I guess what I'm saying is some of these areas were wet for maybe the first 6 weeks of the spring. You know, April, part of May. Used to be pastures and everything. Now they're sloughs.
Oh, okay, I see.
Okay, so they never used to be basically a wetland as far as, you know, months and months of being underwater. And now they are wetlands because they are silted in. And they did not have any, prior to 85, cleaning out or anything of them. But my question is, what can we do legally to clean them back to the days back years ago. Because I live east of Aberdeen, and I have problems out there, and the state highway came in and did some on their highway ditches. And Highway 12 was done in 1966. They cleaned those ditches 2 feet deep just to get back to where the water would run out through the culverts. So since 66, they've silted in 2 feet. And that's what I'm saying is these sloughs have silted in. Let's get them cleaned out, and then we might not have this water will flow out of here.
Well, that may be a matter of getting a wetland determination to identify, was it really, is it really a wetland for USDA purposes? If it's just due to recent wetness, it may not meet our criteria. So that's a matter of working with your local office to see what the case was. And we do have some issues with land that abuts roads, railroads, whatnot, that can have an impact on the water movement off the land. And we do take a look at that when we're out there making determinations.
Right now, the federal crop insurance program is not tied to draining. A producer can still be eligible for crop insurance if they drain. Now, there's a lot of talk out here in the country where guys are talking about draining and so forth. And I guess my biggest fear would be that with the writing of the new farm bill, that Congress would incorporate and tie draining to be eligible for federal crop insurance. Do you guys know, is there a lot of push from NRCS and all the wildlife groups to get crop insurance tied to draining in the new farm bill? And if that were to happen, a guy that goes out and does a lot of draining this spring, would he be grandfathered in if the farm bill's not settled on till summertime? And I'm a wildlife man. I love to go out there and hunt deer and pheasants, ducks and geese. But also, farmers are put on this earth to feed the world, and there seems like there's got to be some type of compromise that we can still save the wildlife, but allow these farmers, one possibility would be to allow them to drain their wetlands back to 1985 levels. And I think maybe South Dakota wheat growers have, not South Dakota wheat growers, as Farmers Union are in favor of something like that. That seems to me like that'd be a good compromise.
Well, I'm going to save our panelists and their jobs and just quote what Chief White quoted to the environmental people recently in a summit in Moorhead. Basically, the chief said, over his dead body will the crop insurance subsidy be tied to compliance. So that was his stance.
Just for clarity, what is the definition of a wetland that is drainable and what is not?
Well, I can deal with that from the USDA perspective. There are other entities out there that have an interest in wetlands beyond USDA, and they may have different definitions. But from our standpoint, there are 3 criteria that we have to verify. One would be hydric soils. Another one would be hydrophytic vegetation or water-loving plants. And it would have to be a preponderance of that, or a site would have to be able to grow those type of plants. And lastly is the hydrology, or the wetness, due to either surface water or groundwater. So it has to meet, for USDA purposes, it has to meet all those 3 criteria. If any one or more are lacking, then it would not be a wetland.
Are there other questions?
Gary, would you address what you see in folks setting up drainage districts and that sort of thing in South Dakota, since it's totally new to us?
Yeah, and I don't know if my microphone is working. Apparently, I permanently broke it. I apologize. And I'll address that just to go back on the earlier questions having to do with wetlands and what's a drainable wetland and those issues, and what can be done about those wetlands that have silted in and those kind of issues. And I'll say generally, when you ask and what I'm doing today is giving generic legal interpretations of what the law is. And so before you go get the backhoe working based on what I say today, you should probably call me and give me a little more detail about a specific case before you hold me to it. Because, you know, attorneys love to throw out depends, and unfortunately with water, it has this beautiful complexity that everybody has a law that it applies to it, and the science is very complex, whether it's above the surface or subsurface, and when you go to drain it, there's a whole number of new issues that come up. But basically on wetlands, the general interpretation of what a wetland, with some variations, is more or less the same with all agencies, state, local, or federal. And that is, you need the hydric soil, the hydric vegetation, and some amount of hydrology, and each law will have its own variations on that. So in South Dakota, there is not the same vigor of what is a wetland per state law, because South Dakota doesn't have a independent statutory enforcement or limitation on wetland impacts, which, say, Minnesota does under the Wetland Conservation Act. So under the Wetland Conservation Act, wetlands are defined about the same with some variations, and you will come across situations where a wetland for state purposes will be slightly different than a wetland for USDA or Corps of Engineer purposes under the Clean Water Act, and they all have their own limitations. So from a federal standpoint, the interpretation's about the same, but then it's limited under the Clean Water Act to waters of the United States, which are those wetlands that are associated with navigable water in some way. And there are different federal circuit courts that have issued opinions which I'm obligated ethically not to say anything negative about a judge, and I'm not trying to do so. But these opinions are essentially undefinable as you read them in some cases, and then each area of the country, depending on what circuit you're in, will have a different interpretation within those cases. So you have to look at specifically what you're dealing with, and then on drainage issues, you get out of the context of wetlands at all. I mean, drainage doesn't require a wetland to be productive or useful or necessary in a particular case, but the jurisdictional kind of catch pin for under the farm program with Swamp Buster requires it's a wetland. If you don't have a wetland, then you can go ahead and drain. And you don't have to, there's no enforcement part of it, it doesn't apply. The farm program doesn't apply to that. That doesn't mean that if you call me up on any given day and ask me, should I fill out a 1026 and submit it before I drain, my advice would be fill out 1026 and submit it, although the agency doesn't have jurisdiction for non-wetland areas. Outside of all wetland issues, you still have other issues, which are civil problems you have with your neighbor that you may have either because you're having water drained on you or you're draining on someone else. As far as wetlands that have been filled in with sediment specifically, and you won't always get agreement with different agencies on how this is to be applied, but basically what you look at, if you have a particular wetland and you're considering whether you can impact that wetland through either surface drainage or tile drainage, and with tile you have to be very careful that there's formulas for how this is to be applied, but there is impact, setback, so to speak, from, as Michelle mentioned, to tile and how it will drain through a certain type of soil, a certain depth, a certain type of tile, and you need to determine how far that impact is, so that if you're putting tile in around wetlands and you don't want to impact those wetlands because you want to stay in compliance with the federal farm program, then what you have to do is make that determination and stay out of that impact area. So the first thing you do when you're considering a particular wetland that has been degraded, erosion or cattails or whatever it is, you have to determine whether or not there is, and the first issue is that it's a wetland. Is it a wetland that for USDA purposes or some other agency purposes, they would define it as a wetland? Even though it may look like one or not one, that's not what you base it on. You look at the formal determination. You might have to have a wetland delineator go out and look at, is it a wetland, and then where's the limits of it. Once you know you have a wetland, or it possibly could be a wetland, kind of the two breakdowns and categories of wetland are those that were, for farm programs anyhow, were those that were impacted, and there's some exceptions, but very few, prior to December 23rd, 1985. And if it has been prior converted in some amount, the rules that apply to that wetland will likely be different than if it has no impact prior to December 23rd, 1985. So you have a prior converted wetland. That doesn't mean that it's not a functioning wetland, that it's still not going to meet the definition of wetland, but you have more legal rights to, on that particular wetland or impacts of that wetland to maintain the existing drainage that had at least started prior to December 23rd, 1985. And there are some allowances, so the drainage may have been done after that, but you had to start in some fashion the drainage before that. So if you have a wetland that has no prior drainage at all, then you're pretty much stuck with looking at, does it meet the definition of a wetland? What's the footprint of that wetland? And you either do not impact the wetland, or you're going to be in violation, or you have to seek some type of allowance for mitigating or replacing the wetland that you did impact. And so you have to go over and restore a wetland someplace else. If it has prior conversion to it, then you're able to maintain it. But there's also the allowance, and this will get you need to do this, you need to do your homework before you do this, but there is allowance that under federal law for farm program purposes, you're able to not just maintain, but you're able, the drainage, but you're able to maintain what's called the water regime. And what that means is that there's been wide-scale drainage, which there is in a lot of these watersheds, and there are inputs into that wetland that are new. So that, just a real generic example would be, that wetland had a 2-foot ditch that at the bottom is a 2-foot cut to drain it out. And it drained it to the point where it was only a 0.2 wetland. Well, now if you restore it to the same 2-foot ditch, it's not going to be the same size, it's going to be 0.8. And that's because, not of natural reasons, but it's because the neighbor's been draining and that ends up going into that wetland, so it doesn't drain as efficiently as it used to. You are able to make that cut even deeper to get back the existing water regime of that wetland. And there is case law in regard to that, and it's been upheld. I have found, based on my involvement with clients, that you will just often, if not uniformly, be violated if you go out and do that without carefully going through that and proving up what you need to prove up and those type of things. So it's a complex thing if you have these wetlands, and it's widespread. I probably have 4 dozen clients with almost that same question, and every factual situation needs to get worked out a little bit different. But there's a way to look at that and at least get the answer. The first thing you need to do is the legal answer before you go out and decide what's the practical answer as far as the drainage and that type of thing. And so without getting too, if there's more questions, we can fill in on that. As far as drainage districts and that type of prospect in South Dakota state law has codified what had previously been South Dakota common law. And so common law is judges have issued opinion in cases, and those opinions have become precedent, and other judges follow that precedent. And so in a given fact situation that is the same, the law should be applied the same. For good or for bad, there's never a factual situation that's exactly the same as another factual situation, and that's part of what attorneys make their living on, is arguing a way that the sun comes up in the east that it really doesn't in this one case. And so you argue different facts. But otherwise, the law has been codified in state statute, and you can look at these earlier decisions to determine kind of what the meaning and the policy of the state law is, and you can generally get a pretty good idea of what you're allowed to do under state law. Along with that, but in conjunction with that set of statutes in the state has set up a statutory framework for, one, having counties enact their own drainage ordinances, which, just in a generic sense, allows a county to add more procedure to drainage within a county, but doesn't allow the county to actually alter what is allowed or limited by state law. So they can't allow more drainage in a county than state law does, or at least the procedure for it, but they can add to it. And so they can say, we're going to have more permits, we're going to have more boards, you can come in you can show certain exceptions and you don't need your permit and that type of thing. And along with that, they can create public drainage projects. And they can go in and they can, and there's a marked difference between urban land and rural land. And that's why I'm talking for here, urban land, because there's this different set of statutory requirements for urban land. But on rural land, which ag land for the most part, not always, because it's incorporated areas you could farm in, but then it's a different set of law. A county can go in, pass an ordinance, and they can set up drainage projects, public drainage projects, for a certain purpose. It's basically a process of petitions. A group of landowners would like to have a public drainage project, and they can go in and they can set up a district, and they can petition to have certain projects reviewed for the engineering, the cost analysis, and you look at, there's an analysis to determine who the benefited acres are and what the cost is going to be. And the statutory authority sets out pretty clearly what the process is that you go through. Of course, there's very few things people argue more about than law, especially or more about than water on ag land. And so it's much easier to understand what the system is than it is to kind of walk through the system. And there are some interpretations that you find difficult within the statute as to what they mean. So you need a majority of the landowners to either petition for the project or to agree with the project going ahead. But the law does not define what majority means. Is it a percent of the landowners? Is it a percent of the acres? Is it a percent of the benefited acres? And so you can run into a number of complexities that can shut a project down just because it's difficult to the point of cost ineffectiveness to go ahead on it. So there is a process. It's relatively straightforward legally. It's much more difficult practically, and it's fairly onerous, and there's a number of steps that you have to go through to do it.
Excuse me, when it comes to making the wetland determinations, in order to do drain tiling and getting wetland determinations that may not have existed before, we've had 3 federal disaster declarations in a row with relation to excess moisture in our area. Naturally, it's going to appear that there are more wetlands because we're going to have the soil types and the vegetation and the excess moisture that is there now. Is there any consideration or looking at more historical information for those particular lands, given consideration for that?
We do certainly consider that. And as far as the hydric soil criteria, it does take quite a bit of time for the indicators in the soil to develop. So that's not going to occur just due to recent wet conditions. So that the hydric soil component in itself may fall out if we come out to look at your site and you've had this recent wet weather and it's certainly not a surprise. But many times we may not find the indicators in the soil to say that it's been wet long enough to meet wetland criteria. Another thing we do look at is the aerial photography. And for the hydrology portion, we tie the aerial photography to the climate conditions, the wetness conditions. And we look at, we use National Weather Service climate data and look at a band of data that's within 20% of either side of what's considered normal. I hate to say the word normal in South Dakota, that this doesn't happen, but there's a band of precipitation we look at within 20% each side of normal. And we look at that over a 20-year history. And we also have black and white photography going back in some counties as early as 1940, which is valuable as far as looking for prior drainage, especially surface ditches. So we do take a look at that. I don't know if I got at your question.
Is there a general rule of thumb as to how many years it takes for that soil to become hydric?
A lot of people ask that, and it's a complicated science. It has to do with temperature, and it has to do with bacteria in the soil breaking down wetting and drying cycles. It takes longer to create those conditions in the colder climates than it would in the warmer climates. So there's really no time period that you can attach to that. It's a relatively long time. It's not something that would occur in the last, say, 5 to 10 years.
That answers it. Thanks.
I have a question about prior conversions, the 1985 date, and what happens when you find one that hasn't been documented, and are you adding, does that get put on the list then? If you've come along and you find an old drainage tile, evidently there was a prior conversion and maybe nobody knew about it. Does that get added to the list then, or is that list where it's at and it can't be added to? So I'm sure there's a lot of places in the state where there's ditches and stuff that were done that were never brought in, were never documented. And what happens when you get to those situations?
Right. We do see that all the time, not so much with surface ditches. On occasion, we do see ditches that were not reported prior to, and we will go back on our photography to try and find those. Tile, that's interesting. We find that all the time. Somebody will go out and do maintenance on a ditch, and they'll hit a tile. Nobody knew it was there. So in that case, come into the office, let our folks know as far as how soon they could add that to your determination. That'll be up to that particular office. But we would probably look at that as new information, and we would try and get that corrected as soon as possible. Usually what we'll ask producers to do is try and identify the extent of, say, a tile, for instance. You may find a blowout, so you know something's there, but how extensively is it? Is it one line through the wetland? Is it multiple lines? So in that case, typically folks go out with a backhoe and start looking for it. You could even water witch to try and find the lines, and once you've got that identified, we can add that to our maps.
I guess I'd like to answer on how you would handle the situation. In our area, we've been wet since, I believe it's 95, when we started losing a lot of our roads. And we had an awful lot of excess moisture. We had ditches that we wanted to clean out. NRCS says we couldn't for a number of years. And we finally did when we come across the terminology blue line ditch. And all at once, then they told us, oh, we never had any say on those ditches, but we've held water since 95 there, and of course, I'm guessing it's going to be determined a wetland because of that. And they never had the right. I feel that they were negligent in telling us about these blue line ditches. How is that handled?
Well, as far as maintenance, it's hard to, like as Gary alluded to, it's hard to give an answer and get you the right answer without knowing all the specific instances tied to that piece of land, because there can be a lot of differences, more than you might realize. If there was a documented ditch there that existed prior to 1985, you certainly have maintenance rights on that. If the area is listed as a wetland or farmed wetland, you would have maintenance rights on the ditch. If it's listed as a prior converted wetland, there are no restrictions as far as what you can do. You mentioned the blue line. That has to do with USGS topography maps, and we've, there are certain areas that are shown on those USGS maps in blue that sometimes the Corps of Engineers has jurisdiction over. Sometimes we do not. get involved in those. So that gets to be a difficult area, whether those, sometimes you could have a wetland and waters of the United States occurring together. But as far as just simply a pre-85 ditch, you should have maintenance on that unless there's some other restriction out there. Any easements?
In the mid-'70s, they told us to get all of our ditches registered, courthouse, which we did. We did have one gentleman that was in charge of our NRCS office, and when he realized, he come into our area not knowing that, when he realized that our ditches were registered, he said basically all we had to do was sign the 1026 to maintain our ditches. And prior to him and after him, we don't get the same answers there. And he still swears that as long as they're registered ditches and all you're doing is maintaining your ditches, that you don't have to do anything other than sign the 1026.
Well, back in about 1990 and 91, after the 85 Farm Bill had been passed, our offices asked producers to come in and verify where they had ditches or any other manipulations. So we have those producer certified manipulations in our office on paper, and a lot of times they took those to the courthouse and registered those as vested drainage rights. So they may occur in both places. Currently, we do take a look at what was recorded, producer-provided information that's recorded on those forms. We take a look at aerial photography and other determinations that have been made on that land to try and identify all the ditches or prior tiling that was out there. We do need to, if nobody had been out there to verify the extent of that ditch, like measure the ditch or check elevations, we would need to come back and do that before you do any maintenance. But other than that, if you have a pre-85 manipulation, you're free to maintain that.
So you had, can I be heard now? Oh, it's working? Good. Your question was basically you had indicated that in a particular office you were given guidance as how it would work, and then people changed and then you get a different answer. And that can happen, just a human dilemma on any office, private or public. The way the rules set out your relief to that, and so if you think that you're given the wrong answer, is you have certain rights, and you have to protect those rights or you could lose them. And what I mean by that is, so if you go in and you fill out a 1026, or you don't fill out a 1026 and you do field work, and you're given notice you're in violation. There's an interplay between Farm Service agencies and NRCS. And so the actual finding that you did something wrong, the technical part may be the NRCS. The impact, the swamp buster part, taking your benefits away may run through Farm Service agency. So you can get notice from either of those agencies. And the most important thing you need to know is when you get notice, by rule, they will put on certain appeal deadlines and certain requirements that you have to do to follow those appeal process through, and there's dates on those. And if you miss those dates, those are dates you might not be able to get back. And so if you do something, or you think you're given, so you do field work and you're violated, and you think that's wrong, you didn't do that, or if you fill out a 1026 and you get an answer you don't agree with, you're not just powerless to do anything. And so if a client comes in and talks to me about that, the first thing I need to know is that whatever action or finding that was taken, that they're still within those timelines. And there are some timelines I can get back for you, and there are some timelines I can't get back for you. I mean, there's no way to recreate the wheel. You've lost out. So you need to be very careful on how you proceed forward and what you do. And this can apply either with whether you disagree or don't agree with the prior converted determination. And there's no exhaustive list under current law that says if it's not on this list, you don't have these prior converted rights. The law says if it's prior converted before 1985, and you haven't abandoned it, and I've worked with individuals that have been found to abandon it, but for the most part, you have to kind of work at that. But if there's not a determination that conversion was abandoned, you have certain rights that go with that. Whether those were vested rights that recorded, that's a proof issue. It just makes it easier to know, so the NRCS office can look at that, and that's good evidence what was done. And if you find tile or you find ditches, and you run into situations all the time where there's disagreements as to, the agency will say, well, we're going to let you do this, but not anything more, because we just can't find evidence of that. Or with wetlands, whether it's hydric soil or not hydric soil. Same type of issue. You get a preliminary technical determination, it ends up being a final technical determination. You can do certain appeal processes. You can ask that the state conservationists review it. You can then go to the National Appeals Division, NAD, and appeal it through there, ultimately to federal district court, and then ultimately appeal your rights within federal district court. So everything is a matter of reasonableness and economic, how much is this land worth to me, and that type of thing. But you have those avenues to go through it. And so you don't just need to rely on the person's answer. You have, the law sets out certain rights that you have. And with every group of human beings in the universe, including, even sometimes attorneys are wrong, these, federal agencies, you might disagree with them, and then you have to go through your rights. And there's a way to work things out, and some agency and the people within that agency you're dealing with are easier to work it out. You always want to try to first work things out, but not let your appeal rights or your other rights go. And so there's a way to bring in to the mix when you're appealing these certain evidence. And drainage is done in a certain way that has inherent proof within it. And so water drains downhill. And so most ditches have some degree of gradient on those that existed at some time in the past, or a tile, and there's certain equations to determine what the likely drainage project would have been, and you can use all of that. But for the agency to beat you, all they have to show is substantial evidence in the record. They don't have to show more evidence than you, or even some percent of it. The term is technically substantial evidence in the record. And so if you're going to disagree with the agency and you're going to go in and contest it, you have to bring evidence in enough to show that some of their findings are wrong, to the point where it's not substantial evidence in the record, or you will lose regardless of how many engineers you get involved in, that type of thing. So when I'm asked to get involved and a landowner comes in with that letter, I look at it, understand what's going on. Generally my advice is we need to get an engineer to look at this that's competent in this area and determine whether that's the right answer or the wrong answer, and then move forward from there.
Can I touch on that just a little bit too? I don't know what particular area you're from, but I will tell you that the folks on the eastern end of the state with more intensive drainage do this type of work every day. A good chunk of their day is spent on drainage and compliance issues. So they're very familiar with it. As you move west and the drainage intensity and history is less, they may not be as familiar, or maybe a little rusty since the last time they've worked on something. So they may need to brush up or check with somebody else in a neighboring county or in their area office. So I'd encourage you to bring your information to them, and it can be that sometimes we don't have a pertinent piece of information that you do. We do have a lot of records, but they aren't. We do find things out there that nobody knew about, and we can add those as we find them. So please work with your local office.
We have a ditching project that was a WPA done back in the 20s, and this spring we were flooded by it, and so we wanted to dig it out. So we went through all the county work and everything, and we have found out that the Corps of Engineers has taken over this ditching project, and it takes over probably a 5-mile area. And where we're at, we're in the northeastern part of Spring County, which is very flat. There is really no drainage. Where this water was made to drain to is called the dry run, which has been flooded for years as is. What do we have to do to get, tiling? Is that available for us through that? Because this ditch has been put in since then, and the core is in there. What restrictions? Because as flat as we are in where I'm at on the township board, we have to ask 3-4 miles downstream from us if we can do this. We know we're not going to get the okay from the people to do it.
So do you mean within the farm program itself, or within the allowance to have an outlet into that ditch?
Well, the ditch drains into this. And so what we've always done is the water, it surrounds farms and stuff, and it just drains into the ditch and goes towards the Jim River. What we're wondering is if we wanted to tile into that and everything, from what we understand the rules is you got to ask downstream whether you're allowed to add the more water to the downstream. Well, the people downstream, their bridges, their roads, and everything that build up, they flood now. They're boxed in all the time below us. There's no way, what rules, do we have to go by through the Corps of Engineers? We went through them, and we did dig some of it out. They agreed. We had an engineer come in, and we dug out 2 miles of it. But there's about another 7-8 miles on 3 different deals that the WPA built, which the Corps of Engineers has control of, that they told us as long as we have it engineered right, we can do it. But we're going to really run water downstream from us. And where we're at, it don't run very fast.
So is it the county that you understand is telling you you have to have permission before you can drain into this project, or is it the Corps of Engineers that's telling you that?
Well, it's just the county, the township rule. The county rule is, from what they've been saying, with all, as flat as we are, the water doesn't drain anywhere. It just goes on to the next guy. And so when we battle township stuff, they're going, well, you have to ask the people downstream whether you can put a culvert in or do anything in our area. And we're just wondering, we've got this ditch, we've got the possibility to drain many quarters of land into this this already existing project. Where's our hurdles going to be, downstream? Is it?
Occasionally disagree with counties and townships, and this would, from what you're telling me, would probably be one of those occasions where I would disagree. And this is South Dakota, correct? Just generically, and this is another one of those situations, what I'm going to tell you, you should make sure to remember what I said first of all, that this is general information, and don't go doing this without talking to me or somebody further and somebody that understands what they're talking about. But in South Dakota generally, and so you're not talking about worried about farm programs or those kind of things, just what you can drain. South Dakota has what's called a civil law rule. And under the civil law rule, on rural property, so it's not incorporated property, you can drain into a natural waterway as long as it's reasonable. And that's the generic language of the case law and what the statute allows. You don't need a permit from anybody. You don't need anybody's permission. The policy of state law is that every property owner, one of the bundles of rights you have as a property owner includes a burden that you need to accept other land's surface water as long as it goes into a natural waterway and it's reasonable. And reasonable is what the courts will tell you is a fact-intense inquiry. So you look at everything about that situation. How much water you're putting on. Are there other ways to do this drainage without putting it in here? Can you limit the drainage to certain times a year? So you can put restrictors on your tile. They look at all of that. How much harm goes to downstream, that type of thing. And the problem with the civil law rule and all civil issues with anything, including water, is a lot of times you don't find out you're wrong until the judge or the jury tell you you're wrong and you owe them a whole bunch of money. So you want to look at it, proactively, prospectively, and look at what you're doing and try to ascertain based on what the law says whether you're allowed to do it in a situation. And a natural waterway isn't a blue line or a creek bed or a stream or anything significant. It could be anything that you can see with your eye or that science would tell you water would naturally otherwise flow. And you can put it into that natural waterway with certain restrictions. One of them is it can't be unreasonable. And the law generally defines as unreasonable is you take water from this watershed, and I don't mean watershed in the big sense of the word that the Corps of Engineers said this is the St. James River watershed or anything like that, but that it's just, or the James River watershed, but that it's just, the water would just naturally fall on the surface and go a certain way. So the natural flow of the water is to go to this outlet. But if you take it from this watershed and put it into a different watershed, even though it's a natural waterway within it, that is more likely to be considered unreasonable than as if it's going to ultimately get to that pond down there, and you're not making it get to a different pond down there. It's going to go there, but you're just taking it from spread out in your field, the surface water, channelizing, you're putting it in a channel that is a natural flowage area that's going to otherwise go to that pond area there. Under South Dakota law, you're fairly safe if you do that. Now, you have to do it in a way that doesn't change the natural flow of the water to the point where it becomes unreasonable. An example the court found that was unreasonable is the water would have always got there, but you changed the timing to the point where instead of flushing out all in the spring, it kind of dribbled all year long and saturated the soil so it never was usable. And so you have to be careful. But the beauty of South Dakota law is if you can stay away from all of that, no one can stop you. You don't need a permit from anybody. You don't need government approval from anybody as to just putting the water down there. You might be violated under a program or that type of thing, but you're otherwise under South Dakota state law, you can do it. So there can be permit requirements in certain cases, and one of those would be if it's one of these public drainage systems. There's permitting requirements for having an inlet, so to outlet your water into it. They would require a permit then to put your water into it. Part of the reasoning, the policy that there can be some limitations under state law is that everybody has to pay for that public system, and there's this assessment process based on who the benefited properties are, and if you change how that works, the cost way that's divided up is thrown off. And so public systems are allowed to have permitting requirements for inletting into them. So if it's that kind of thing, then they can have permitting, and what typically is required in those cases is you fill out an application and you have to say, here's what I want to do, here's when I'm going to do it, here's the safeguards I'm going to put into it, and then there's under the ordinance or the Public Drainage Authority would have a set of guidelines on what you have to meet to get that permit. You can protect your rights if you think they unfairly don't let you do it. If you fit these criteria, then they are bound to give you that permit for the most part. But other than that, just because they're telling you can't put your water in there doesn't mean you can't put your water in there. Not in South Dakota. Because you just got to be careful before you do it that you don't violate the civil law rule, because a government agency can protect their property just as you can. If it's unreasonably drained on their property, then you could be civilly liable under the civil law rule potentially. Does that make some sense?
I guess just to add to that on a technical aspect, there's the legal issue, but then technically if that ditch isn't draining properly and you start tiling into that, those overall drainage system is only going to be as good as that final outlet. So making sure that water is actually moving before you start directing more water in there is going to be important. Some folks may see some benefit the farther up they are in the system, but eventually things are going to get submerged and then you're just not draining anymore. So there's the technical issues as well as the legal issues as far as making that work properly.
This is a question for Gary. In South Dakota, generally, how far downstream do we have to get permission?
There is, under state law, there's no requirement that you get permission downstream. And so there's a question whether a particular county could enact an ordinance and require that. I think they would be legally on weak ground to require it. And so there isn't really any requirement under state law. There's something to be said about not getting sued. And so if you get permission from people downstream, I think there's a natural benefit there if you can work with them. But I worked in this area, and so I drove through here this last spring a number of times around Aberdeen and south of here to Redfield and points south. And I don't think you could have got any of the landowners that I drove by to agree to let you put more water on their land. And so it's not real easy to do that. North Dakota has very specific requirements under their law that make it more difficult. And this is a question that is going to be answered legally. And if any of you got land in North Dakota and want to kind of define what state law is, I'd be glad to help you do that, because it's a lot of those water boards are requiring a certain distance downstream, and what most county water boards are arbitrarily choosing is a mile. Now, there's nothing scientifically meaningful about a mile. Sometimes you could hurt a person 10 miles downstream with water. Sometimes an eighth of a mile, and there's no practical harm because there's an infinite outlet, you know, as far as from a local standpoint. But under South Dakota law, there is not any downstream requirement restriction. Counties may enact, and I think they probably have legally weak ground to do that. But, you know, counties do a lot of different things that, and until you question them, they get most people to comply.
And it does vary county to county. Some have downstream notification of varying distances. Some actually have it in written that it's supposed to be downstream permission. So it depends on the county, and it does mean checking with the county to see what those actual permit requirements are.
As we wrap up this session, one final question. Chris, would you talk just briefly on the research and the practicality of more or less developing a closed loop system if your land allows it, or you're containing the water that you might tile away, you might recycle it, reuse it throughout the growing season?
Sure,
Let this be our final.
And I guess I'll talk about it from a couple different levels of complexity. One of the things we encourage, and especially on land that's suited for it, which tends to be flatter land, which you've got plenty of that around here. But on flatter ground, you can put in some control structures at the outlet and perhaps a few others in the system, depending on your topography. And with those control structures, what that allows you to do is raise or lower that outlet elevation. And so then that gives you the ability to control when and how much water you're releasing. And so, you know, through the year you could manage that in the spring or in the fall when you need to get out in the field, you can pull those boards out and allow that water to drain out. And then at other times of the year, you can put those boards back in and allow the ability to store some water back. And so, you know, research is still new on this. We're hoping that it actually potentially results in some yield bumps just by being able to hold some water back for later use in the summer. So that's one level of complexity. The next level of complexity then is if you've got a separate water source, or if you want to build an area for some retention of water, you can hold some water there and then pump it back through those same drainage pipes using those control structures to manage that water, and then allow what we call sub-irrigation, where you're putting water back through those pipes and allowing it to work its way back up through the root zone and again supply that crop. And so that's another level of complexity, but an area where, again, you're getting the maximum bang for the buck. You're getting drainage when you need drainage, but you can also add water back in to help feed that crop when you're water short. And so it's something that's, you know, it's been around for a number of years, but especially in areas like this where we're certainly susceptible to both being water short and water excess, it's something that's an option out there that folks are increasingly showing some interest in.
Thank you, and thank you to those who raised questions. We appreciate our panelists being here. Again, they will be around. Feel free to corner them, ask questions, watch the website for more information and their contact information, and we have small tokens of our appreciation to share. With that, Steve Briggs will turn the meeting back over to you.